Thereafter, Professor Robinson then joined the law firms of Foley Gardners in Washington, D.C., and he spent a long time to practice there, where he primarily consulting clients relating to strategic and IP ownership, acquisitions, and also that what he has done during his practice with very busy billable hours, he wrote law review articles. And his law review article last year was selected among the best law review articles in law reviews relating to patent law. And it was republished in the Patent Law Review of last year. With that, I turned over to Professor Robinson to chair this panel.
Thank you very much, Professor Nguyen. It's an honor to be here nearing the home stretch of my first year as a professor. And so this is, for me at least, an excellent way to cap off my first year here. So the panel that we're going to discuss several strategies related to specific provisions of the America Events Act that will go into effect the fall of 2012, so right around the corner. And what I wanted to do is put together a panel that could discuss these provisions from various strategic and professional perspectives. And what we're going to attempt to do is take a closer look at a few of those provisions, most notably post-grant review, the inter-parties review, supplemental examination, and the third-party submission provision of the America Events Act. And so when I got the idea for this panel and wanted to find out, started thinking about who I was going to ask to be on the panel, I wanted to find the very best people available that I knew to help me not only make sense of the law, but also people that were thinking strategically about the law. I'm very pleased to have these three panelists with us today. All three at one time or another in their career have worked at some capacity at the USPTO. All three are excellent lawyers that also at one point in their career practiced law at Foley and Lardner, which is how Hal is still there, which is how I met them. And finally, all three are thought leaders in the field of intellectual property. They've all written and spoken extensively about the American Invents Act, and I think you're in for a informative treat. I'm going to start with introducing them with Hal. So Hal Wegner, he's a partner still at Foley and Lardner.
Still there.
Hal focuses his practice on appellate patent issues as well as re-examination and other complex matters at the U.S. Patent and Trademark Office. He also crafts strategies for multinational issues, particularly Chinese and Japanese patent enforcement and management. He's the former director of the Intellectual Property Law Program at George Washington University Law School, where he's been a professor of law, and he still continues to be affiliated with George Washington University Law School as a member of the Dean's Advisory Board. He started his career as a patent examiner, and in 1994, the firm which he founded merged with Foley and Lardner. And then to Hal's left, we have Sharon Barner, who is currently Vice President and General Counsel at Cummins Incorporated, which is a Fortune 500 company that one of its major products is the diesel engines. It's headquartered in Columbus, Indiana, but as Sharon informed me last night, they keep the lawyers in Indianapolis. So we appreciate her traveling down from Indianapolis to join us. From 2009 to 2011, Sharon was the Deputy Undersecretary of Commerce for Intellectual Property and Deputy Director of the USPTO. She also led efforts to craft the strategic plan for the USPTO, which actually will tell you focused on optimizing timeliness and quality. And that strategic plan is 2 years into effect. I think it was 2010 to 2015 were the dates for the strategic plan. And as we'll talk about, one of the goals was to improve the appeal and post-grant processes of that strategic plan. Before that, Sharon was a partner at Foley & Lardner, where she served as the department chair of the intellectual property department, as well as a member of the firm's management committee. She's tried dozens of patent litigation matters, and in 2008, she also spearheaded the opening of Foley & Lardner's Shanghai office in China. And then finally, to my immediate right, we have Jonathan Spivey, who is currently a partner at Bracewell and Giuliani in Houston, Texas, in the litigation practice, where he focuses on intellectual property litigation, including patent, trade secret, trademark, copyright, and unfair competition litigation matters. His trial experience includes federal jury and bench trials, with key participation in numerous district court litigations, also involving patent, trademark, copyright, and internet domain disputes. Jonathan has experience as a patent examiner and served as a judicial clerk for Robert Mayer, former Chief Judge of the United States Court of Appeals for the Federal Circuit. So if you could please welcome our panel. All right, as I said, one of the goals of this panel is to talk really about the strategy that practitioners are going to employ and are thinking about with regards to these prospective provisions. And what we wanted to do was start out with the post-grant review provisions, even though it's only going to be available for patents that have a priority date later than March 15th, 2013. One of the things that Nathan mentioned in the previous panel is that it might also be available for patents that fall under the transitional program for covered business method patents. So my first question for the panel is within regards to costs. So according to the 2011 APLA economic survey, an inter-parties re-exam costs about $278,000 from start to finish. The filing fee for a post-grant review challenging 20 claims or less is going to be $35,800. And recent estimates state that attorney's fees are going to be within the range of $500,000. So my question to the panel is post-grant review, is the cost worth the benefit for post-grant review challenges?
So I'll start. It depends. As you heard one of the gentlemen say, he's got a case that's $5 million. They're $5 million into it, probably with no end in sight. So, when you get a case of that magnitude, of course, you look back and something that would cost you $500,000 in attorney's fees and $35,000 in filing fee seems well worth the challenge. But I think $500,000 is probably on the low end of what it will cost to begin with, because what will happen, you look at the ITC proceedings that also have had historically a mandated completion of 1 year to 18 months. People didn't spend less money, they just spent more money in a shorter amount of time. So if the patent is really worth something, it is highly likely, and there's a real issue to the business, it's highly likely that it will be hard fought, whether it's in the district court or at the patent office, and that more money will be spent and not less. And so you don't want to fight over your garden variety patents in this proceeding either. You really want to make sure that the issues that you fight about are ones that are significant to the business and have a real impact on the bottom line or getting the product out of the door if you're going to have a proceeding in which you spend this kind of money.
Go ahead.
Yeah, I agree with Sharon. There are a couple points. First, it is a compressed time. Now, it's not 12 months. It's really a couple years, because the first, the entire case by the challenger goes in with a petition, and that starts a 2-month period for a preliminary response, which you may choose to waive. And then there's a 3-month period for the director to institute proceedings. These 5 months are not included in the 12-month period. Bang, the gun goes off, the 12-month gun goes off when the director orders the proceedings to start. And you all will already have had all of your challenger's evidence, affidavits in the case. And this is heavily stacked in favor, by the way, of the challenger, because he or she has as much time as they want to prepare for this. Then you start the clock really going fast. You have 4 months for the challenger to take depositions of the experts, of the patentee of the challenger, and to file the response with the declarations, affidavits by the patentee. Then there's a rebuttal and so forth, and then there's the motions, and then there's a hearing, and the gun goes off. The 12-month gun sounds at the end when the decision by the board is reached. Now, after that time, there's still a possibility of petition for reconsideration, and there's the entire time for the appeal to the Federal Circuit. It takes about another year. So it's not just 12 months. It's this extended time. Now, is it worth it? There are two answers to that. In lieu of litigation, yes, it could be well worth it. There also will be situations where the patent owner is being totally unreasonable with a very, very weak patent. And here you may want to file a challenge, particularly if this patent owner has lots of licensees already, because the beautiful little gem buried in this act is a settlement provision, that you can have a settlement at any time up till a board decision, and then this wipes the slate clean. It just wipes it off the face of the earth. So I can see the reality therapy to a nasty patent owner, that you can file a case, and if you've got a very strong case, you may not need that much ammunition. So that's it in a nutshell. There's going to be a spike. There's not going to be many cases filed. Patent attorneys, I think, are notorious in the entire profession for not liking changes in their cages. They don't like new things. What's this new procedure? And it's for that reason alone, there won't be that many filings. And it's really a Japanese proceeding in a lot of ways. Unlike the German proceeding and the European proceeding, which goes on forever, this level, that level, and auxiliary claims, and so on and so forth, this is, in large extent, modeled after the 2004 Japanese invalidation trial law, which starts and finishes at the board, and plus an appeal to their court. And that is averaged about 7 months from start to finish. Now, we're much more ambitious in having more discoveries, affidavit practice, and depositions of the clients. Now, there will be a spike in many filings right at September 16th. Because unlike the inter-parties reexamination, which started prospectively only for patents with a filing date on or after November 29, 1999, as of September 16th, the gun goes off for any patent still in force. So going back to the last century, patents still in force can be challenged. So there should be some challenges filed of these patents. But after that, the filings will go way down, I think.
If I could take it from a different perspective and use the previous comment about a case in a litigation, patent litigation, 4 million, 5 million in, probably no end in sight. I think it is strategically will be good if it's a competitor on competitor suit. And let's say that as part of the business, you monitor your competitor's patents, and you have an understanding of the landscape and the scope of their patents. You have to assume that they do. It will be a great opportunity for you at that point to then get in on it and limit it, and not have to be involved in a litigation, and be able to limit the amount of spend. In a patent litigation, it's very hard to limit the amount of spend because discovery plays a huge component of it. And patent attorneys by nature want to always take a no stone unturned approach. They want to look at every document, every email. They want the other party to produce it. They want to see it. And that's just by nature part of the litigation process and brings up, and it extrapolates the cost of it, which is probably why you're at that $4 million spend and probably halfway through the process. So I think it'll provide a tool, especially in on competitor type cases where you're evaluating and monitoring your competitors' patents, their portfolios, and understanding the landscape of where they're going, because it's important to your business, your products or services that you're going to put out. It becomes very important at that. Now, for a case, if, let's say your litigation is one where it was a patent that just really came out of the blue, you had nothing, you didn't know about it, it comes from one of these newly acquired, newly created entities, I'll call them. And their business model is really to license, to extract licenses and fees. In that particular circumstance, whether or not there's a $500,000 spend on legal fees and including the cost of the petition is questionable, because a lot of times those kind of cases can be resolved for much less than that. So it's questionable whether or not that'll be a procedure that you want to use in those instances. But I think in competitor-on-competitor cases where you have real legitimate concerns about protecting what you have, your interests in technologies, it'd be a tool that can be used.
So it's for these newly created entities, which I like that phrase. So for those, generally you can, they go away for about $100,000 in $100,000, $200,000 in licensing fees. So that's not a situation where this, in your view, that's not a situation where this post-grant proceeding would be beneficial.
Yeah, it's very hard to track. Because those patents unfortunately come out by the hundreds, the thousands. And so if it's not something that's really within your realm of vision or a part of the technology that is the mainstream of your company or entity, then it's not something that you're going to pay attention to. But if it is something that is part of what you pay attention to, kind of the landscape of the technology or where you envision your company going because of a new product or service, then it becomes a really good tool.
No, but on the other hand, in these newly created entity litigations where you have big defense groups, which may be changing given the venue provisions in the law, maybe, because there have been ways that folks have used to get around those venue provisions already. But when you have a defense group of, let's say, 10 or 15 companies, what I've seen from companies is that they will say, you know what, I'm tired of paying $50,000 or $100,000 just to get rid of this. So I'd rather spend that $50,000 or $100,000 with my other defendants, pool the money, and challenge this newly created entity's patents. And it might indeed, in those instances, be a more efficient way for those defense group folks, especially if you know that there's a more limited scope of dollars involved, to challenge in this kind of a proceeding. So, in some ways, when I start out and I say it depends, you've got very different kinds of litigation that may go on, or challenges in this area. And so there isn't a one-size-fits-all. But the whole purpose of these post-grant proceedings was to make it easier and more effective and allegedly less costly for companies to challenge patents as part of the entire process of getting good quality patents out there.
Yeah.
Go ahead.
Well, the other aspect is we've been looking just at costs, like there's no difference in the fora. But there is a tremendous difference in the fora. Everyone who litigates knows what discovery can do for you and the wide sweep of prior art defenses, which you can't use in inter-parties review, only printed publications. But some issues are uniquely suited for the patent office, particularly cases where there's a continuing application. So oftentimes, the big issue in a case is here this claim was crafted years after filing in a continuing application. Does that claim have priority to the first filing? And if it doesn't have priority, there's an intervening publication that creates a statutory bar. This is a very difficult issue for a court to understand, bench or jury, but it's an issue very easy for an examiner to understand, the question of priority. Is there written description support in this parent for this claim? And where you have such a written description issue, a clear-cut written description issue, where it may be a crapshoot in a district court, here you have a dead nuts situation where you're going to win this case in the patent office, and if not, you can win that on appeal at the federal circuit.
Yeah, Hal's dead on right about that. I've had cases where we've had that argument, and it was very hard, no matter how well you tried and how simple to make the argument with regard to them being entitled to the earlier date or not, for the court to really grasp and understand that. And it was something that usually wasn't corrected until the case went up on appeal. But after that, you're $6 million in, and you really kind of lose faith in the system. And he's right, the PTO is better situated to handle that type of argument, and using it through one of these procedures makes it better for that.
So let's talk a little bit about the factors in this that would go into a decision to challenge or not challenge a patent. If you're in the, as Jonathan said, if you're in the competitor versus competitor context, what does a challengeable patent, what factors are you going to look at to decide whether or not you're going to challenge a patent under these post-grant procedures?
So let me just start from the company perspective. You know, from my perspective, what we've had in the past are companies who say, you know, I don't want to go out and find out what my competitors are doing in this space, because if I find out what they're doing, then there's an obligation that I have that, because of the law, that puts on me this good faith, issue of whether I should continue to make this product or whether I need to do something different. So we sort of stuck our heads in the sand and said, let's not find out what's out there. And this changes the landscape, I think, in some very dramatic ways. The whole intent in part was to put some pressure, some responsibility on the companies to monitor the landscape of their competitors to see if there are patents that are coming out that they want to, if there are applications that are going on that they want to submit prior art on. And there were a couple of programs designed to get the companies to submit prior art to see if that would create better claims in the end. So this puts somewhat of a burden on companies that they heretofore did not have to look out at the landscape to the extent they weren't. I would say to you, most companies have some idea of what their competitors are doing in their own space, especially if it's an important product. But here is a burden that's clear that you could spend less money up front if you were watching and monitoring your competitors' patents by submitting information during the application process. Or you could wait to the end, engage in a post-grant process or litigation if you think that patent really speaks to products that you have out there on the market. So the first thing I would say is you need a change in the company mentality about monitoring their competitors' patents and having a good procedure for doing that, because it will be important to how you go about challenging the claims or the issued patent.
Yeah. Could I just add one little factor to this on monitoring patents? One of the points that has not been looked at too much has been the pre-issuance submission. I think this can be a very valuable tool. It's an anonymous tool. It can be supplied anonymously. And in essence, what you can do, the Patent Office has the authority to charge fees. They do if you cite quite a few references, but you never want to do that. You can cite up to 3 references, preferably 1 or 2, that are the most pertinent references. They might even be the references cited by the applicant in his background of the invention. And you can provide a claim chart and show exactly, precisely how the claim reads on this prior art or an obvious embodification. It's free. It's anonymous. And you need to do this before the first action. And I think that's a very good tool in some industries where you have so many patents, where you have to follow that, where you're following the patents. And the goal is not to flood all the prior art you have. That's just going to get the examiner upset and they won't look at it. But if you have, I can tell you if I were an examiner, again, I would welcome having somebody, a respected attorney, filing a 3-page comment to prior art in the specification that says, here is how the scope of the claim, here's why the claim reads on this prior art or an obvious embodiment. And as the minimum, you're going to get a first action rejection based on this prior art, and then hopefully the applicant will have to amend. Now, in the past, we say, well, don't shoot your ammunition off because then how are you going to challenge it? Well, it's not your grandmother's Board of Appeals anymore. You had about 60 board members as little as a year ago. We're going to be up to 200 by the end of this year, and we're going to 300. Again, this is following the Japanese model, which has 22% of its core is appeal examiners. When we had 60 board members, that was 1% of the core. And these are different people than the old board. It used to be, turn the clock back to 1961, they had 15 board members. There's an article in JPOS, I think by Federico, who had a chart, a listing of all the board members. The average time, all of the board members were former examiners. They all had an average time before they got to the board of 29 and a half years as an examiner. And until recently, almost all of the examiners who almost all examiners who got to the board. Now, the cross-section of people coming to the board are some very bright, in their 30s, former federal circuit clerks, litigators, and so on, who might want a lifestyle change where both spouses are working. Jackie Wright was a partner in Foley and Lardner, and I encouraged her to take the job. She was on a Star Trek. She's a full partner. She's making a lot of money. But her husband was in the Department of Justice, also making a top-of-the-line salary in government. So maybe they weren't used to living on more than $350,000 a year as a couple. And it's a nice job being a judge. Those are the kinds of people you're facing. And I always remember talking to, some cocktail parties and receptions, the board members say, well, I don't know how to control this thing. They submit back. I say to myself, you guys are the judge. Control them. But they don't know how, because all they've done is examine cases. These people coming from the outside, they're not going to put up with that nonsense. Right. And so if you cite the prior art in its pre-issue and submission, the examiner doesn't play ball with it, you've got a new de novo review by the board that is not going to give any deference to what the examiner has done. It's a different culture. You're getting a different caste system out of this.
Yeah, I'm going to circle back to the pre-issuance submission issue, but Chair, I did want to ask you, so one goal of the strategic plan was to improve the appeal and post-grant process, and Hal talked a little bit about the constitution of the new Patent Trial and Appeal Board. How does the new Patent Trial and Appeal Board further that goal of improving the appeal and post-grant process, and what do you think it's going to be like to be in a legal proceeding before the new board?
Yeah. So I think a lot of what Hal says is true about the constitution and makeup of the new board. But under the strategic plan, there were a couple of things, and a re-engineering process was part of it. When you look at the amount of steps you have to go to get through an appeal or any other process, it's completely ridiculous, because you can get through a Federal Circuit appeal in 3 filings, but it takes 100 filings to get through the board. So simplifying that process was one issue of bringing down the time frames that were involved, getting more judges. If you get more examiners, you're going to process more patent applications, which means there are going to be more things before the board, which means you need more board members. And you need a different constitution of some of those board members if you're going to have different procedures. You need people who understand litigation, who understand the games you can play in litigation, both with discovery and filings, and who have the temerity to say, no, we're going to reject this pleading because it doesn't follow the rules. No, you can't give me a pleading with 500 pages of things if the limit says that the brief has to be 100 pages. That's what I want from you. So you're going to have people who will stand up and say no to the applicants who are the petitioners who are before the board. On the other hand, you need to have people who know their stuff, right? you need to have some confidence that the people who are on the board are competent to do what they're doing in terms of looking at these very important appeals, because otherwise those things would not be before the board if people weren't willing to spend a lot of money on something that was important. And Hal is right. I've seen some of the new judges coming in. You have a lot of Federal Circuit clerks who have decided that this is a great new opportunity. It's a new board. They can make a big difference in the overall patenting process by being a part of the trial appeal board. You have a lot of people coming from law firms who have tried cases that are going to be on that appellate board. And you have an increase in number, and they will have to deal both with the new proceedings and the appeals coming up from the examiner. And so I think you can expect to see, both through re-engineering some of their current rules, being very adamant about following the rules in the same way that the Federal Circuit clerks are adamant about people following the rules. Before them, you can get a brief kick at the Federal Circuit quicker than you can bat an eye if you don't do what they say, including playing with the margins and any of those other things you do to file briefs. You will see people who will be sticklers for those rules because it increases efficiency in what they have to do. And so I think that for many reasons, there'll be a lull at the beginning, but once people understand that they can actually get a better process before the trial board, that they will start using that board more.
If I could just say, I think the bigger picture of the whole thing is, I think the end goal and the main objective is going to get it right. They're going to try to get it right. It won't be, and what you find in a lot of district court actions, I don't think the district court, they focus on getting it right, but it's trying to get through the process because you have so many other cases behind. You can't really get through all of the issues like you need to as thoroughly as you need to. So there's less of a chance of getting it right. But I think here in this process, they're going to get it right.
Yeah, and part of getting it right is getting it right, yes or no, affirmed or reversed, in a timely fashion. And one of the sacrifices that has to be made is these foolishly long opinions on routine cases. Mm-hmm. And I'm encouraged to see the per curiam procedures being used. Is that part of your strategic plan?
Right. So part of the strategic plan was getting folks back to, you don't need to have a 10-page opinion. You know, if you're just going to affirm, you can do that per curiam. And changing in some ways. There are a lot of internal things that led to lengthy delays. You know, the seriatim review of the board, the 3-judge panel, you know, one person review it, and then another person reviews it, and then another person reviews it. That all adds to the length of time. So really just looking at the process and procedures again and seeing where time could be cut off of a process. And just one little point on the re-engineering of getting the applications themselves down, the whole process more efficient. Director Kappos has a re-engineering process going on at the core. It is not a short process. It has to be a long process because there's a lot in there that needs to be done and cut out of the process. You know, when we looked at the board's process and appeal, we were able to cut out 6 months just by looking at duplication of effort and procedures. 3 people reviewing for technical conformance with the rules. 3 different sets of people. 1 will do. Okay, so you need to get in there and just find those things where duplication of effort. So, you know, I think that you will find this board willing to do it. You will find the director capable and willing to cut those processes off. And it's a two-way street because you have to not only have the people on the board willing to do that, you have to have practitioners who are coming to the board willing to play by the rules.
And understanding that the gamesmanship and kind of the nonsense that goes on in a lot of district court cases is not going to happen when you're in front of the PTAB. One of the things is a funny kind of thing. I remember when I first started clerking for my judge, and he sat us down and he kind of talked to all of the clerks at the same time. He says, inevitably, you're going to walk around and you're going to be doing this. And I was like, what the hell is he talking about? He says, you're just going to be doing this. He says, you're going to look around and you think you're going to get rid of a case, and you're going to look at your hands, and there it is again. And you're going to keep trying to throw it away. The cases just keep coming back, keep coming back. Well, I think one of the things is, when I talk about getting it right, you know, make a decision, and then if the other side disagrees with that decision, it goes up, it's appealed, and then it's done. You know, you live with whatever the ruling is, and you may disagree with it, but there's got to be a sense of finality to it. It can't be a continuous fight, continuing to fight. And I think trying to get these procedures in place gets you to that point a lot quicker to reduce what the ultimate spend is on these things. When at the end of the day, it could be just, well, I disagree, and I want to keep fighting. And there's always been an avenue to keep fighting. And so I think by having the board, having these individual board constituted with new people that are going to try to stick to what the rules are and the procedures and force the petitioners and the parties to do that, I think you'll get to that determination a lot quicker.
Yeah, one of the questions that some people raise is, well, how do these new board members coming from litigation practice, have never been in the patent office, how do they deal with the patent office procedures? Well, the answer there is the three-member panel. So my understanding is, as you get new board members coming from the outside, they're great in substantive patent law, they understand procedures, and they'll be married on the panel with career examiners who've been promoted to the board. So you'll have a cross-blending of talent. The other aspect, we talked a little bit about the board is a different animal than the examiners. It used to be, board members used to be called examiners in chief, and they really were rubber stamped to a large extent for the examining corps. And then Commissioner Lehman gave a little title inflation and became APJs and so on. But now they're really a different culture. We've seen that with appointments. And the board has really a de novo proceeding. So in some senses, when you get a second action non-final, you'd like to appeal it if you can, because if it's clearly a bad rejection, take it up. But if you don't win at the board, except for claim construction, which is de novo at the federal circuit, you're toast, because it's a substantial evidence standard, and so the right to appeal to the federal circuit, except for claim construction, is to a large extent theoretical.
So I want to look at it from the other perspective. Jonathan, again, you mentioned that in most cases, we're looking at a situation for the post-grant review procedures where it's a competitor versus competitor situation. What if you are the patentee? Let's say your patent hasn't yet issued yet, but you know that it might be likely that it's going to be subject to some sort of post-grant review proceeding. Are you working closely with the prosecutors in preparation of that patent to add other claims, or how are you strengthening your patent for a post-grant review procedure, if you can?
Okay, so here's what just a couple of thoughts I have on kind of the patent owner strategy. If you know that you're going to be challenged, or patent's going to be challenged by one of these procedures. So you know that if you just take the literal language of what's been a year, then 6 months, you can have for extension for a good cause, but then Hal talked about the time getting to that year, so 2 years or whatever. So you have some understanding of where you're going to be in the process and how long it's going to take. You have to make sure you understand and identify all of the discovery that will be needed. Let's say if you expect that the challenger is going to come with a post-grant review, or you really have to understand that. You have to know what affidavits, what declarations, what particular testimony of the inventor, and it can't be one of those things where you kind of wait to see what it is, but you kind of be assertive and understand what's going to come out of the person's mouth. And you have to kind of anticipate what the arguments are going to be from the other side as to why, the patent is invalid. Understand if they're going to make a 101. Understand if it's going to be a 112 type of argument. I mean, it's your patent, it's your inventor. You understand the specification. Know that. Don't wait for them to point it out for you and then be reactive, but be proactive about it. The other thing that you have to understand is if there's any pending litigation going on, understand the impact on that. So you don't want to unintentionally surrender some of the claim scope in this process through the PGR process. You definitely want to be careful of that. I mean, I've had instances, and this is when the inter-parties review, the inter-parties reexamination, I think worked quite well in the litigation. My client was sued for patent infringement, and immediately we filed the inter-parties reexamination. And through the inter-parties reexamination, we put up a real good fight, and ultimately, they said something in a response. And it came in, we looked at it, it's like, did they really just say that? Did they really just narrow the scope of the patent like that? And when they did that, it ensnared the prior art. There it was. And it was a gift. So you have to be very careful about that because you don't want to unintentionally do that. So those are the kind of things that you have to be on the lookout for if you're expecting a post-grant review kind of challenge.
And John has made a very, very important point. You have to be prepared as the patent owner. And by preparation, that includes really collecting all the KSR factor evidence you could gather. If you wait and don't prepare, you have this 5-month period when the petitioner files his arguments, where you have the 2 months for the preliminary response, 3 months for the decision by the director. Then your 4-month gun starts for your preparing for your your response, and you need all of your evidence in at the end of that 4 months, and collecting comparative test data, collecting articles by experts in the art contemporaneous with this to show the KSR factors of design needs and so forth. You just can't have a naked affidavit by an expert saying, in my opinion, this is a KSR factors are fine and wonderful. You've got to have very specific facts. You need all that time to develop this. You may want to do comparative testing over the prior art. That may take a long time. You've got to be ready for that stuff.
So I would say, if, as the patent owner, we file about 300 or 400 patents a year, and you can't have that process with regard to 300 or 400 patents a year. So one of the things you want to do as an owner is you want to know what patents cover your primary products, right? Because that's critical. And if you've got some applications that are pending that cover your primary products, and that I say that with a big quotation mark because frequently the product changes over the life of its development and the patent claims don't, right? So you don't have your patent people in touch with your product development people because they don't know that you started changing things that are necessary as you develop this product. So before those claims are finalized, you need to make sure they're actually covering your product and if need be, your competitor's products, right? And that to me is a refinement that frequently does not occur at the point at which it should occur in the claiming process. So from that perspective, you need to make sure that the claims are strong. And frequently we've had a litigation team look at the claims because frequently the patent folks will get focused on language that doesn't necessarily hold up down the road. So if these are important patents and important claims, you need to put a little bit more effort in making sure that the claims are strong. Because at the point at which it can be challenged, every time you get ready to change it, you have all these strategy issues to talk about. What am I going to say? Am I going to limit my claims? Am I going to do this? Whereas if you do that on the front end, you're going to have less of these issues of things like Jonathan says, derailing your strategy as you're in the course of this post-grant review or challenge. So as patent owners, I would say you need to be looking at those claims before someone else is looking at them.
And there are two things you can do on a routine basis. One of the big weaknesses in many patents is the lack of a subgeneric claim. There's a very broad claim one and then some very narrow claims. And many times you need to retreat to a subgeneric claim. So you need to be sure that you have a subgeneric claim that covers your real commercial embodiment. Because what happens in these post-grant proceedings, they're subject to intervening rights. So they really don't help much. That's the first thing you can do. Always be thinking in terms of a subgeneric claim to cover your commercial embodiments with some generic scope. The other thing is, I like to have a divisional case that I can file just before the issuance of the patent. And divisional patent then can go trail for a long time, and then I can add claims based through that divisional case without intervening rights and through an ex parte procedure.
That was the other thing I was going to mention, is that you definitely want to avoid inadvertently creating intervening rights when you're in this post-grant review or inter parties review process. And the strategy that Hal is talking about is a good way of doing it, because you don't want to get in there and start changing the claims. When you do that, then you're creating the intervening rights.
So, Sharon, it seems like one of your suggestions, I guess the way I'm envisioning it working in a practical context, is that you are identifying the patent applications that cover your main products, and then in addition to having one of your top prosecutors on that application, you're also having it looked at from a litigation perspective. So presumably there's a litigator that's also looking at the claims and making sure that your patent is in good shape just in case one of these challenges come about.
Yeah, again, you can do this for all your patents, but if you have key products that you're putting out there on the market and you know that there's going to be a lot of competition, this is a patent application that is worth the extra effort in making sure that the claims are strong. And I add the litigator in part because one of the things you see from a litigation perspective is how claim language goes wrong, right? And so when you have a litigator look at it, you have a broader view of things that they've seen in litigation and language that you might not ordinarily see from the prosecution perspective. So I think having a litigator touch up the edges of some claims is a very good way of strengthening your claims for those key products or processes that you have.
So one of the things that I wanted to circle back on now before we open it up for questions is Hal mentioned the pre-issuance submissions, the third-party submissions, and how you seem to suggest that it should be targeted, although at least my reading of the proposed rules suggests that you could submit up to 10, you can make up to 10 document submissions, and then for every other 10, there's a new fee. So could you talk a little bit more about your strategy?
You have to be insane to file 10 or 20 or 30. Your goal is to help the examiner. And I can tell you as an examiner, if you gave me 50 references, I'd throw it away. Why would I want to look at that? That's nonsense. You want to pinpoint, you want to get the examiner's attention, you want to be his friend, you want to help him do his job. So for example, one of the major uses of the pre-issue submission is going to be these wonderful little backgrounds of the invention section saying, we have surprising results. This U.S. patent such and so teaches this and that, and we are patentable versus that. Baloney. So do a claim chart and explain exactly why the claim is this broad and why it reads on an embodiment in the prior art or an obvious embodiment. And maybe have a second teaching reference perhaps, but very simple and not argumentative. No case law or anything. Just say this teaches this at column this and this teaches this, and leave it there. And now you've made a perfect first action rejection for the examiner. He's going to be very grateful for your help. But if you start having many, many references, you're just foolish.
Yeah, I as a former examiner, Hal is exactly right. You want to be as simple and as direct as possible. If you have, let's say you have 10 references, and let's say you've gone through and you categorize them, as the top 3, then the other remaining, there are 3 more, and then there may be, let's say, 3 more that are good, and then you have this last one. And I would suggest that you take the top 3, but the 1 or 2, you focus on them, you hit it hard, you put the claim chart there, and you show how it would invalidate it, and be done. Just keep it simple, brief, and that is the best way to serve the process. Because as a former examiner, when I would get, multiple references, you know, you would see the patentee would give you like 60 references, and I'm thinking to myself, now all of these can't be important. But then once I became a litigator, I understood what the hell was going on. We just hiding what it is in the 60s. They just hide it, and now I got to go ferret it out. But, you know, under the time constraints, I didn't have the time as an examiner to do that. And, you know, now if you're going to do this submission, obviously one of the things you're trying to do is help the examiner lay it out and make it very simple.
Right, so here's the other side of the coin. Because I've looked at hundreds of prosecution files, and and there's always been this hesitancy to give the examiner your best prior art if you are the person, you know, because you could submit stuff before. It's always a hesitancy to give the examiner your best prior art because the other side, who is engaged in the prosecution, is going to argue around it, right? So now you've just put your best stuff out there, and you've given the applicant an opportunity to figure out and craft arguments around the best prior art. So there's always been a hesitancy to give the examiner your best prior art. They only have so much time, unlike the people who are prosecuting before them, who have unlimited time to make their arguments about why their invention is patentable over the prior art. And so I've just seen instances in which the examiner was right, the examiner was right, the examiner was right, the examiner gives up. I got to get on to my next application. I can't keep fighting over this. And so some claim gets issued that was properly rejected from the very beginning. So how do you deal with the hesitancy of folks, which you will have in pre-issuance submission, to submit your best information, even with a claim chart, because of this arguing around that the applicant can do?
Yeah, that's a very tough spot. It's a good question, actually. Because you'll be in a spot where it's called this whitewashing process of your best piece of prior art. If you know that it may be something that you may see later on down the road in the litigation, because, I mean, one of the reasons you're really commenting on is because, you know, this is a part of the product or something that we have in the same area. So this is why you're submitting it to the PTO to have whatever patent that your competitor is trying to come out with, in a sense you'll be faced with litigation later on. It's tough. And oftentimes you'll have where particular entities will hold back, and instead of giving maybe the top one, they'll give the second or third reference.
Yeah, but there are other, it's a case-by-case answer too. First, sometimes you are not yet in the field, and you see this claim, very nebulous, very broad, and you don't really care what claim is granted as long as the boundaries are clear. And here, if you have very pertinent prior art, you will force the applicant to characterize his invention in a way to create estoppel. The other aspect is, if this is an important case that is worth the money for an inter-parties review, then you have this fail-safe option at the end. Remember, this is not your grandmother's board anymore. This is going to be totally de novo proceeding by people who are from a different culture than the examiners. Not only are they from the outside, but they're lawyers, whereas 99% of the examiners are not lawyers. So you'll have a de novo proceeding where you haven't had it before.
So before I open it up for questions, I wanted to get the panel's perspective on supplemental examination. We had the previous panel talk about it a little bit. I wanted to get your perspective on whether or not you thought that supplemental examination is going to be frequently used, and how it will be used by the patentee.
Yeah.
I don't have any opinion on
that. That's very rare. I've known Hal a long time. That's very rare. I think there is, I could just say from what I understand of the supplemental examination, I think the previous panel kind of talked about why they didn't think it was very pertinent or going to be used very widely. But timing and preparation are important. And I think if there is a reason or an opportunity to act, failure to act could result in the loss of the inequitable conduct safe harbor benefit. So if there is an opportunity for you and there's probably a need, and I mean, obviously, the patentee is in the best position to evaluate whether there's a need to take advantage of that safe harbor benefit, I would suggest that you be objective and honest with yourself about whether you need to invoke it.
I think it will have its limited applicability, and that there will be some, I can see some instances in which it would have great use. Frequently, companies don't, it's not that they're hiding a reference. It didn't come to their attention that a reference existed, even though somebody else in the company may have had it, right? You know, if you have 20,000 engineers, it is highly possible that some other engineer in the team may have an article while you're prosecuting a patent, and it not come to your attention until late in the day. And so it is, I see circumstances under which it might be very useful to have supplemental examination from the patent owner's perspective to get those issues cleared up, so that in the context of a litigation, you're not being accused of inequitable conduct, since your whole engineering team is you, right? You know about it if anyone on your engineering team has it. So I do see that there may be an increasing opportunity for this, especially as we get engineers who are more remotely removed from the actual process, innovation process and team, who are out there in the field, who nonetheless will be considered part of your knowledge team by having a piece of prior art or some additional information.
Pretty rare use, though.
I could have used it a few times in my litigation career.
Yeah.
All right, well, great. I'd like to open it up for questions now for the panel. If anyone has questions, please.
We solved all the questions? No.
Yeah, you mentioned a de novo review of the board. I was wondering when you appeal that, is that going to go to the CFC, and what standard review is that? Is it deference? What sort of standard?
Substantial evidence, right?
Yeah. Substantial evidence.
Yeah, substantial evidence for the obviousness and the fact-based issues. The only one that is going to be de novo will be the claim construction or errors of law. And even the claim construction could go by the wayside if Cybor is overturned. That's something just waiting to happen.
Yes.
For anyone, do you think the board should be permitted to apply broad and reasonable interpretation claims in the proceedings? There's some controversy about that.
Sure.
I would, yes.
I mean, we have to follow the law of the Federal Circuit.
But the review is something different. It's not an examination.
Well, when you're looking at 112 issues, if you're looking at it from a legal perspective, you are looking at it very broadly. The issue has always been, for purposes of for purposes of claim interpretation, it's the broadest possible, and then you narrow that down when you're looking at other issues, and so you get this dichotomy that isn't quite right. So I think you need to make sure that you can look at it for both purposes in its broadest sense, both for looking at the claim and for looking at the prior art on that claim.
Yes, sir.
Just briefly following up on that, so if in these inter partes review processes, we're not going to, say, deference to the presumption of validity.
Sure. All right.
So if there's no deference to the presumption of validity, in a way, why isn't it a no-brainer to file this? If you can validate the patent
They're expensive.
without having to
Yeah.
deal with the presumption of validity.
They're expensive.
Yeah.
Well, the lawsuit's expensive.
Yeah.
Right, now, are you talking about once you're involved in the lawsuit, or are you just talking about off the bat, just do it, I mean, just strategically?
Because someone has a lot of money.
Right, right.
Lawyers,
Right,
which is a good thing, of course.
right.
But if one was motivated to invalidate a patent defensively for some reason because they're concerned about the patent without being sued on it,
Right.
maybe he has sent out letters to other people.
Exactly.
For whatever reason, and you're evaluating the alternative litigation for
you have, yeah.
Well, let me just finish up, but under this new procedure, where you have, say, more, a board with more aggressive, position for the patent, and you don't have a presumption of validity, you have a limited right to prevent, that's a much more slanted proceeding in favor of the patent challenge.
But it's definitely, the statute was definitely designed to be anti-patentee. There's no question about that. But when you go to a district court, you have massive discovery, which you don't have in either of these procedures. You'll be able to take the deposition of the affiance, and that'll be it in the inter partes review. That will be the only procedure generally available for 2 or 3 years.
So let me just, go ahead.
I was just going to say that most patents get invalidated, when they're invalidated on summary judgment in a district court anyway. So you're really dealing with paper procedure.
And you do have the chance for discovery of the affiance here, which you did in an inter partes reexamination.
So let me just first of all take issue with the fact that the statute is anti-patent. I disagree. The genesis behind the statute was to make it more conducive to challenging the claims as part of the process, to take the millions of dollars that are being spent on litigation and try to neutralize that by getting it back before the experts with an opportunity to review the issues post-process, right? Post going through the application process and the give and take. So the notion that you don't have a presumption of validity is because you're right back at the place that issued, that was, that is issuing the claims, which differs when you get to a district court. So I don't think that's anti-patent. The goal is to put it back before the experts, this to become a process, a part of issuing good patents. I mean, everybody says a bad patent should not issue. You should get those off. So this is part of issuing claims that are allowable by law and good quality patents. And so I agree that it tries to give an incentive to people to do that because that's what they want to happen, to help the quality of patents that are out there, and to do it in a cost-effective manner by removing the presumption of validity, which you shouldn't have. It hasn't issued in many instances. It's part of the issuance process now.
Yeah. Oh, okay, so I guess the point I was going to, if you're talking about making the decision between whether to file, if you've gotten a nasty letter, hey, this is my patent, would you like to take a license? Let's just make it this. Whether or not you want to file a DJ action, or do you want to go through one of these procedures? Again, you have to look at what evidence are you going to need, what kind of discovery are you going to need. You're going to have to look at all of these things to determine which of the process will be better. If you know it's going to be something that you're going to need extensive discovery, then obviously the DJ action is going to be the best way. If it's something where, I got the silver bullet in my back pocket, they didn't know it, why not use one of these procedures as the first tool? And you decide between, again, kind of the scope and the type of discovery of what you need, and to keep in mind about the estoppel effect as well for both of those, and determine which one would be the best way to proceed. Do I have a situation where I'm going to challenge that this is not even patentable subject matter? Obviously, that determines for you, you're going post-grant. Is it a situation where I have a written description type of issue? Again, post-grant. But do I have the prior art, anticipatory prior art in my back pocket? It could be PGR, or it could be the inter parties review. And you have to make that determination based on what you need, which avenue you're going to take. And obviously the timing considerations for both of those procedures as well.
Well, do you think that a lot of the expensive discovery will be eliminated by the elimination of the 102G, who invented first issues, and the elimination of best mode? And I mean, wouldn't the 112, 112, and 103 issues that are now going to predominate the invalidity aspects, if you've already done all your research, wouldn't that really bode for going through one of these post-grant processes versus a district court?
Well, I mean, in a lot of the district court litigations, I mean, best mode was something that when it came up, and maybe it came up, I don't know how frequently it came up, it wasn't something that at the end of the day, at the trial, that was going to invalidate the patent. It's just one of those things, you raise it, you try to give the other side hell about it, but are you really going to determine that the patent is invalid because lack of them to provide the best mode? No. If that's what you're going to trial with, you might as well pay them.
But a lot of money was spent on.
A lot of money, and that's where you can now cut down on the process, and let's really get to the crux of the issue. Is it really patentable over what's out there? Was it novel and non-obvious, or was it in fact was it not patentable from the beginning?
You're going to have a lot more expense added by the new law when you talk about the post-grant review, which will be applicable to patents based on applications filed on or after March 16th next year. The new prior art regime includes foreign public use on sale and disclosures. So right now, for example, there are 1 million Chinese and Japanese patents, utility models, designs, which have no counterparts. Now, you search for those, and the date isn't good enough because you have just the publication date. So you want to move the date earlier. You're going to have to take discovery in China or Japan to find these earlier dates. Just think of that, 1 million pieces of prior art in Mandarin and Japanese, which have no counterparts in the United States. So you're going to have a lot more. That's just the tip of the iceberg on the foreign discovery. It's going to make a lot of caviar flights to Asia.
Yes.
Yeah, I had a problem in litigation. We had in litigation, the defendants identified literally every patent that had been filed by the longest communication. There were 4,000 patents and that in textbooks and other stuff. At the same time, re-examination was filed in USPTO. And we're sitting there going, what the devil do we do with all this stuff? And identified all this material that was relevant in the litigation. We finally stopped it in equality rules. We had to send everything in the USPTO. And of course, the examiner was mad as a hornet. And like my boss was talking to us, said, what do you want us to do? It's been identified as relevant in litigation. And we don't see any choice but to give everything to you and let you read through it. We're sorry, but we don't know what else to do because of the litigation and the law.
You're obligated to do it, yeah.
Well, I would have filed a motion with the court against the other party to make them identify what was really relevant. It seems to me it's an abuse of discovery in the first instance. I mean, you can just over-disclose in the same way that you can under-disclose. And 4,000 pieces of prior, and I've seen judges do it. You could find law on this issue, say, no, you got to come in here and pick the real prior art.
It was in front of Judge Ward, where you could tell what they were doing. They were trying to get state litigation. They were trying to get state litigation. They let the re-examination draw on for several years while they had waited through all that part.
Right.
Of course, Judge Ward said, no, and that's state litigation.
But let's be fair to the process here, because I've been on the other side, I've been a defendant, and I might not have used those kind of tactics, but let's say that you filed the re-exam and you have identified the best 5 references. Part of the problem I think a lot of the district court judges were facing when they would say, when they look at the re-exam, the other side will throw up these stats, oh, it's going to be 5 years, you're never going to get a real decision that's going to get to the crux of it. And the court is saying, look, I have this case in front of me, I can get it to trial in 24 months, you're going to get a fair determination based on this, let's do it this way so you're not going to get a stay. And sometimes I would argue that that is right on if the process, if what they're trying to do is delay. But there are often times when defendants have a reexamination that really has some substance to it and should be given, the PTO should be given the time to look at it, because they just didn't get it right the first time. They missed something. They didn't have it in front of them. Where this is where the time that it took for the reexamination to complete killed the fact that you really had a reason to get a stay. But I think the new tools that they have, because of the time constraints you have, the 2 years, it's going to be done. It's going to be a written opinion. There's an estoppel effect on it. It's going to have a different kind of maybe appearance to the judge that maybe this is something where a stay would be more appropriate.
And the success of this whole procedure, to a great extent, is going to depend whether the patent office can stick to these time limits.
That's
I
exactly
want to go back
right.
to whether you had any other choice than to put 4,000 references for the examiner, because
Right.
I think there are lots of other choices
That's
than
not,
to take 4,000
Yeah.
references and put them before the patent
yeah,
examiner.
that's a true indicator that you don't have anything.
Right. I think you could have used some of your options with the court
Yeah.
to limit the 4,000 references you had before you put them before the patent examiner. I may these days defend patent examiners more than others, having worked with them for a couple of years, but, there are other ways to get what you need, even if they had strategic options that they were trying to get that 4,000
Yeah.
winnowed down.
Yeah, I think there's one more question over there. too.
Oh, can we take one more question?
We have time?
Okay, the last
So-
question.
This is kind of unrelated to that question, but you're saying, a pre-issuance tool to bring really important pieces of prior to the examiner's attention. Sometimes maybe the patentee brings 60 or 100 references to the examiner's attention, and maybe they're intentionally varying, but maybe it's just that the patentee is uncertain as to the engineer's requirements. Do you feel that there should be clearer, requirements?
I don't accept that. I don't accept that. If you are an experienced practitioner, you have prosecuted patents, you know exactly what the rules require. And I've been there, I've done it, and I've done it as a first-year lawyer, and I still understood what the IDS requirements were. And I think that, again, you have to be honest to the process. If you know whether something is cumulative, you know whether or not you're just piling on, or whether or not there's really a distinguishable difference between reference 5 and reference 50. You know there has to be some distinguishable difference. And so if you look at them and you're honest and you're giving the examiner really what is deemed to be important. Now, I'm not suggesting that you're going to take a wide turn and everything is cumulative and you're only going to give one of the 50. But
If the patent owner has dumped in, or applicant has dumped in 60 references, and I, as a third party, give him a 2-page concise summary saying, this reference is pertinent to column 6, lines 42 to 37, and it says here, quote,
yep.
and the claim reads on this because of this. End of story. No argument. Just an explanation. That examiner is going to be so happy. He's got a first action rejection. He'll take that a turn and say, this is my rejection. Go fish.
Yep.
And on that note, we'll conclude. Thank you to the panelists.